Blackman. Josh, please. Thank you.
Richard, thank you so much. Oh, hi, I'm on mute. Richard, thank you so much. It's a pleasure to be here on this Saturday morning. We have this surreal week where we're talking about scholarship. And it seems there's so many more important things to talk about, but we will do our best to to address this topic. I want to hit a few primary points, five to be precise. Op-eds, amicus briefs, blogs, social media, and video. And these are the five facets of scholarship that I want to talk about today. So first, I want to talk about op-eds. This seems to be a persistent area where law professors often choose to write about. Op-eds are a way of reaching mass audiences in language that appeals to non-scholars. You can publish op-eds in print newspapers. Those tend to take longer. You can publish op-eds in online periodicals like maybe Slate or National Review. Those tend to be quicker. There are challenges with op-eds that are worth discussing. The challenge is a balance between speed and accuracy. Most op-ed publishers want you to publish as soon as humanly possible, which means you have to move quickly. And often when you move quickly, you are less careful. You don't have as much time to reflect. You don't have as much time to get feedback. This concern is especially pronounced with breaking news. In the last 4 years, very often I started writing an op-ed and then a tweet came out which completely changed the direction of the op-ed. Things move very quickly. And you have to be very careful that what you put on paper today may be relevant tomorrow when the op-ed comes out. You're not going to be obviated. Why does this matter? When an academic writes an op-ed, they're not merely just writing as a pundit, right? You're not Paul Krugman and Maureen Dowd, hopefully. I mean, it'd be nice if we were like them, but we're not. We're writing with some sense of stability, bringing some sort of perspective that's more thoughtful, at least in theory. But editors increasingly want punch. They want jabs. They want zingers. And when law professors begin to include those punches, jabs, and zingers, it could diminish credibility because it becomes harder to distinguish you from the Maureen Dowds and the Paul Krugmans of the world. But it's a useful exercise, and I think we've seen a lot of op-eds in the last few months. I know Vikram Mars has a few that were pretty important on some of the pressing con law issues that we've faced in the last, I don't know, since November. So that's a very timely area. The second facet of sort of alternate scholarship I want to talk about is amicus briefs. And this is a old hobby horse. In the Supreme Court and increasingly appellate courts, law professors often submit briefs. And these can take different forms. The most common is the scholar's brief, where maybe a handful of professors write a brief, and then they solicit the brief for signatures. Sometimes 5 signatures, sometimes 10 signatures, sometimes 100, right? Sometimes 1,000. You also have scholarly letters, right? These are letters to perhaps a Congress or various administrative agencies, which might have 5 signatures, 10 signatures, or 100 signatures. Dick Fallon, I think, exposed this topic very well in a paper he wrote years ago. I'll only repeat what he said. There's a risk when professors simply put their name on something that they didn't themselves write. They are accepting whatever the author wrote, which might be at odds with what they think, or maybe they haven't completely given it thought. My rule of thumb is the more signatures a brief has, the less weight I give it. Because obviously if it's that generic to appeal to that many people, it's not saying anything that important. Otherwise, that's probably a controversial statement, but I believe it. I no longer sign briefs that I didn't write. I stopped doing it years ago. I became too uncomfortable letting someone else dictate what my name goes on, right? I would not let someone else write a law review article that doesn't have my name on it. I wouldn't do the same for an amicus brief. So either I'm the solo author or serve as counsel, but I won't just slap my name on a brief. One facet we should talk about is the brief in support of neither party. I would like to see more of those. I've filed a couple of those over the years, and they're hard to pull off. But I think it's helpful when a scholar says, look, I have no dog in this fight. I don't care which way the court goes. My concern is giving the court some sort of accurate information. Apply it as you will. Here's what this provision of the Constitution means. I don't know how it affects the outcome of this case. I would love to see more of those briefs. I think they actually help courts and really build credibility. The third area of sort of alternate scholarship I want to talk about are blogs. And blogs have gone through ebbs and flows. Legal blogs started in earnest in the early 2000s with the Vol conspiracy and a few others, and balkanization shortly thereafter. And they've become popular, and I think they're now sort of on the downcline. They're fading. The sort of group blogs simply just don't get the sort of posts that they used to. I think that's unfortunate. I know judges read blogs. I know lawyers read blogs. And it gives you a chance to weigh in on issues in a timely fashion that law review simply can't give you. There's something called virtual briefing. I do it all the time, where after a case is argued, you write about the questions that were asked and give alternate answers. Lawyers hate this because they can't do it, but we can. So the virtual briefing, I think, is a sort of effective way of using a blog to affect the judicial process outside the amicus briefs. But often blogs are very important. I can't tell you how many blog posts I've read and maybe written that have affected debates for good and perhaps for ill. The next area I want to talk about is social media. And this is not a positive development. I mean that sincerely. Twitter, I think, has been a disaster for the academy. I mean that sincerely, truly. I think it has affected the way we communicate. It's affected the way we have discourse. And it's affected the way that we approach each other. Twitter, if you don't use it, don't start. But Twitter encourages very short 1 or 2 sentence responses that go back and forth without much reflection. Often academics get into lengthy public arguments, right? These are not debates, Richard and I sitting across a table and going back and forth in a respectful fashion. These are people throwing barbs, and then third parties jump in. Then it's just melee. I think Twitter has been very destructive. I actually quit Twitter over a year ago. I stopped checking my notifications. I don't look at other people's timelines. I quit. I use it for a very limited purpose, PR. I post my stuff one way. I don't ever see people respond, and it's a beautiful thing. But I recognize there's a cost. Reporters often quote Twitter. You will see the New York Times, the Washington Post, quoting a professor on Twitter saying, Professor so-and-so tweeted this. So the advice I'm giving you does have a cost. You are limiting your ability to affect the public discourse by eschewing Twitter. I think the costs are far worse. The benefits, I think, are trivial, but it's an addicting technology. But I do want to flag the fact that a lot of scholarship is being developed on Twitter. People are making friends and making enemies on Twitter. People are attacking each other on Twitter. Friendships are being burned on Twitter. Right? It's not just Trump. Right? People using Twitter in our profession for ill. Maybe we should all be banned for a year. Maybe that'd be healthy. Okay. I have about 2 minutes left. Oh, there was a question from the field. What type of amicus brief would I prefer? A brief in support of neither parties. Right? You're saying, look, we don't support the petitioner. We don't support the respondent. We're just opining on this very narrow, discrete issue of law. Court, do with it as you will. A brief in support of neither party. I filed 1 or maybe 2. I can't remember, but they're hard to pull off, but you can do them in rare occasion. The last facet of alternate scholarship I want to talk about are videos. Now, in the last year, we've all become experts in videos. We're sitting here on Zoom, staring at our camera all day, right? We're all making videos. Now, I think we'd be honest, production quality is not the best, right? It's good enough for COVID, right? In an emergency, in a pandemic, we give our students this sort of asynchronous, this sort of on-demand video they can watch. But let's be frank, it's not the best work. Over the past 2 years, Randy Barnett and I at Georgetown created a video library, 12 hours of common law videos that are pretty high quality. We filmed them in a studio, high definition. We incorporated the audio from the Supreme Court hand-downs. We used the oral argument audio. We made these interactive, rich videos that bring these cases to life. You can listen to oral arguments of the great cases. You can hear the justices handing it down in their own words. And the students have reacted very well to these sorts of videos. I'm working on a similar series for property and also eventually for criminal procedure. I want to do the entire canon in this sort of video style. Now that more and more of education is going to be on Zoom and asynchronous, we should think seriously about how to make high quality videos and not just screen sharing random stuff we put together in 5 seconds. The digital generation responds well to video. That's what they know. And I think they can learn from it, and colleagues can learn from it as well. One final plug, put your lectures on YouTube. I know you're afraid. Oh no, people are going to take my... Just do it. Your students will love you. Whatever video service you use your school is not good. YouTube's better. And you can share your information with the world and make the world a better place. 5, 4, 3, 2, 1. I yield my time. Thank you.
Hello there. I want to first thank Richard for inviting me to participate in this important conversation. It's a privilege to be in such distinguished company, and I'll keep my comments